I'm deeply obliged, Malad. I'm sorry, Malad, I somehow got logged out.
Yes, sir.
Malad, before lunch, I'll give your lordships the broad propositions
Yes, sir.
that I wish to address your
Yes.
lordships on, Malad.
Yes, sir.
Now, Malad, in what circumstances is a matter transferred to the CBI, Malad? Just let's look at it, Malad, from a conceptual standpoint.
Mr. Sibal Justice said, your lordships may kindly excuse me for some time. Yes, yes, sir. Yes.
Now, Malad, supposing somebody files that, some corruption is going on or some wrongdoing is happening, Malad, what does he normally do? He will go to the police station, Malad, he will lodge a complaint, give information to the police of the commission of a cognizable offense, and the police will lodge an FIR and start the process of investigation. Now, if the police does not register an FIR, what will he do next? He will go to the magistrate and under 156(3), he will seek the investigation of the agency. Right, Malad? That's the second thing that he will do. Now, Malad, if the investigating agency is not investigating the matter, months pass, years pass, no investigations take place, what is his remedy? Then he comes to the writ court and he files a petition under 226 and he says that, look, I did this. I went to the police station. I gave them information. They did nothing. They were sitting for months. I went to the magistrate. The magistrate directed them to investigate. They have not been investigating. They've been sitting for years. I have no remedy. I file a petition before you under 226 and please direct the investigation to take place, right? Or if you feel in the facts and circumstances of the case that the investigating agency is not purposely investigating the matter and because of certain other interests involved, some high public functionaries involved, then please send it to an independent investigating agency. Well, that's the first thing that he would do. This did not happen in this matter. Right? Well, he goes in July. Then he goes under 156(3). Magistrate says, get sanction. Sanction is given by the governor. And then the Lokayukta gets into the picture. That's right, brother. So that's what happened in this case. So the normal circumstances, your lordships would not allow a petitioner to move the court for the purposes of sending a matter to one agency or another. That is one aspect. Now let's conceptually look at another situation. That in fact, brothers, an FIR is lodged, investigation is going on. Brothers, yes. And status reports are filed. And brothers, the particular person concerned who has lodged the complaint is not happy with the course of the investigation. Right? He's not happy in the way in which the magistrate is also dealing with it. So he goes to court under 226 and he says that, look, this investigation seems to be biased, right? It seems to be colored. It doesn't seem to be going in the right direction. And therefore, you please direct this matter because I don't think the state agency, investigating agencies are interested in investigating this matter. They are moving in the wrong direction. So please direct this matter to be sent to an independent agency. Well, that's also not happened in this case.
It gives reasons for why it's
right. And then, Malad, in that situation, the powers of the investigating reports are filed in court. The status reports are filed in court. Both parties are aware of it, and both parties argue the matter. And then the court comes to a conclusion based on all the judgments that both sides have cited. Well, I will not repeat, both sides have cited in what circumstances your lordships will then refer the matter to investigation. That's, Malad, the second conceptual situation. Now the third, Malad. You take a case, Malad, where a particular investigation is being conducted with respect to a drug cartel, which has cross-border implications. Right, Malad? The investigation is going on in the state. There is no taint in the investigation either. The petitioner will come to court and say it has extraterritorial ramifications. It may deal with a drug trade. It may deal with sexual abuse. It may deal with chit funds. It may deal with any number of matters which have terrorism. It has then of course the NI will take over it. It has cross-border implications. And therefore the court will say that, look, the state police, or sometimes it happens that there are highly technical issues involved, like SEC regulations, some special statutes. And the court says, look, the central agencies are much more conversant with these issues. Let the matter be decided. That's the third set of circumstances in which the matter can be transferred. There is a fourth set of circumstances. Now, and that fourth set is that if those who are being investigated are themselves the accused. For example, the police is indulging in sexual abuse and they become accused in the case, and the state itself is going to investigate police officers of that very state, right? And then the court will say, no. These people themselves are the accused. The police agencies themselves are the accused. How can we allow that state to investigate the matter, right? Then, the matter is transferred outside. These, if I understand the law correctly, these are the only 4 situations in which the matter can be transferred out. Now, with the greatest respect, the petition filed in this court doesn't fall within any of these situations. It doesn't fall within in any of the situations. So that's the first submission, that I wish to make before your lordships. The second submission that I wish to make before your lordships is even more important. In every case where the investigation is tainted, mala fide, not going on properly, both parties are aware of what the investigation has been, what has been the investigation carried on. And it's only after hearing both parties that the court decides that, no, I need to transfer this matter out. In this case, at least the state is not aware as to what is happening. The state is not aware as what has been the investigation. Nobody knows, neither the petitioner knows, nor anybody else knows, or those who are standing for the accused know, as to what investigation is going on. And in the absence of that knowledge, how will anybody decide that the matter will have to be transferred somewhere else? There is no instance in the history of the court where such a thing has happened.
No, if the investigation is shoddy, then yes.
No. That investigation has to be known to the people concerned.
Yes. After getting to know. Yes.
That's right. Therefore, then they have to argue as to why it is not shoddy or why it is shoddy. And then your lordships will decide. That's the other way, that's one way of doing it. There is no other way. There is no other way in law for for a matter to be transferred out in any fashion. But I'm coming to that. I'm just giving your lordships in what circumstances. We are in a different situation, different from all the cases that have been cited by both parties, according to me. Right? Because there is a report that is filed with you. Right? Parties don't know what that report is. Right?
Yes.
Now, what happens, and the PIL petitioner, because your lordship is a special court, the PIL petitioner, supposing the report, now the third conceptual argument, supporting whether the final report is filed or a closure report is filed. Right, And if a closure report is filed, what happens? What is the jurisdiction of the magistrate? He, then allows the PI, gives a copy of the closure report to the PIL petitioner. Right, your lordship knows, in Zakia Jafri's case, that's exactly what happened. The closure report was filed as far as the Gujarat matters were concerned. And then the magistrate gave the closure report to Zakia. She filed a protest petition. And then the matter went right up to the Supreme Court, and I argued that matter. So, then the third set of circumstances is a closure report stands filed. The magistrate gives the PIL petitioner the opportunity to file objections. So the entire matter is before the court and before the public. Then the prosecuting agency, Malad, says that, look, this closure report has been rightly filed or wrongly filed. Right? The accused will say it's wrong. I mean, the complainant will say it's wrongly filed. And the accused or the prosecution may say it's rightly filed. And then your lordships will decide. Right, Malad? Conceptually, these are the only circumstances in which a matter can be referred to another agency. Right, Malad? Now, none of these circumstances exist in this case. So the fundamental question which your lordships will have to decide, can you as a court have the jurisdiction to refer a matter to an agency outside the state without any of the parties knowing as to what the report is? In other words, does the court, it's not a jurisdictional issue, but it's an issue of fairness for us. Does the court on its own come to conclusions? Now, with the greatest respect, Malad, it's my humble submission that that's not possible in law. That's just not possible. It's never happened in the history of this court. Right, Malad? Now, these are the three conceptual arguments that I wish to make. Now the more important argument. The entire basis of the arguments of my learned colleague Maninder Singh is that the chief minister is involved. Right, Malad? And therefore, the state cannot investigate, even Lokayukta cannot investigate. Now, Malad, if that argument is right, Malad, then the Lokayukta Act, to the extent that it allows the chief minister to be investigated, is unconstitutional. It has to be declared unconstitutional. Because as a matter of law, my learned friend cannot argue that because the chief minister is involved, therefore the Lokayukta cannot investigate. It's against the statute. The statute says that the chief minister will be investigated. Not only will be investigated, has been investigated in the past and has been convicted in the past. So yes, there was no taint then. There the chief minister could have been investigated and convicted. But in this case, the chief minister cannot be investigated because he is the chief minister. Somewhat, Malad, a very ingenious argument which cannot stand the test of law. What does the Lokayukta Act say, Malad? Kindly have a look at the Lokayukta Act. Because this case, Malad, throws up issues that have never arisen in the country before.
That's the problem.
I'm sorry?
That's the issue to be decided now.
No, correct. I'm saying that, Malad.
Yes, yes.
There is no procedure known to law. No procedure, and I say, Malad, with some amount of responsibility, known to law, by which your lordships on your own can refer this matter to the CBI without anything more, by just looking at the report.
Yes.
Or Malad, agreeing or disagreeing with the report. Malad, what does the magistrate do? He may disagree with the report.
No, that is his
Then
domain.
I'm sorry?
That is the magistrate's domain to disagree with the report.
No, but your lordships are in that position.
That way, yes.
I'm only saying that, Malad. That's why I'm making that submission only because of that. Your lordships are in that position. Your lordships may say, I don't accept it. Therefore, reinvestigate the matter.
Yes, that is permissible.
Right?
Yes.
That's what the magistrate would do. That you reinvestigate the matter, or I accept the report. And if I accept the report, then the protest petition can be filed. But that will have to be done at the level of the magistrate. Because ultimately, this will go there, Malad.
Yes.
Right, Malad? So then he can file a protest petition if there is a closure. If there is no closure, Malad, then he'll be prosecuted. There are only two possibilities. Or your lordships will say, I am not happy with this investigation. There are certain other matters that need to be investigated. Let the Lokayukta investigate those matters and reinvestigate the case. That's your lordship's jurisdiction. I'm just indicating because conceptually your lordships will have to decide. Forgetting about the judgment, these judgments are only to show that, look, CBI in certain circumstances is entitled to investigate. I'm not on that issue yet. Now, kindly seek the Lokayukta Act. Statements of objects and reasons. Right, third sentence. The bill provides for the appointment of a Lokayukta. I'm sorry, much.
Yes, sir. I'm there.
And one or more Uplokayukts to investigate and report on allegations of grievances relating to the conduct of public servants. And the public servants who are covered by the Act include the Chief Minister. Right, Malaj? Then, after that, Malaj, sentence starting, Malaj, in paragraph 5, where after investigation into a complaint, my lord has that?
Yes, yes.
Middle of the paragraph, where after investigation into a complaint, a declaration that the post held by him, complaint, the Lokayukta considers that the allegation against a public servant is prima facie true and makes a declaration that the post held by him and the declaration is accepted by the competent authority, the public servant concerned, if he is a chief minister or any other minister of the state legislature, shall resign his office. And if he or is any other non-official shall be deemed to have vacated his office, and if an official shall be deemed to have kept under suspension with effect from the date of the acceptance of the declaration. So, and then if after investigation the Lokayukta is satisfied that the public servant has committed any criminal offense, he may initiate prosecution without reference to any other authority. And prior sanction required under the law for such prosecution shall be deemed to have been granted. That's the power of the Lokayukta. So, Malaj, how can my learned friend, and that's my learned friend's argument, Mr. Maninder Singh's, that he is the chief minister, how can he be investigated by the Lokayukta? I mean, an argument that is contrary to very framework of the statute. He cannot make that argument. Now kindly see, Malaj. Kindly see the Act itself, definitions. Section 2, subclause 3. Chief Minister means the Chief Minister of Karnataka. Right, Malaj? Then 7, section 7. Matters which may be investigated by the, I'm sorry, my lord has that?
Section 7, yes.
Yes. Matters which may be investigated by the Lokayukta or an Uplokayukta. Subject to the provisions of this Act, the Lokayukta may investigate any action which is taken by or with the general or special approval of the Chief Minister. In any case where a complaint involving a grievance of an allegation is made in respect of such action. Right. Then, Malaj, that's it. So, Malaj, therefore, this argument of my learned friend that the Chief Minister is involved and therefore, the Lokayukta cannot investigate the matter and must be investigated by the CBI is per se against the terms of the statute and cannot be countenanced by a constitutional court. Right? So, Lokayukta has jurisdiction. You must assume now that Lokayukta has jurisdiction because the Act gives him that jurisdiction. And indeed, that's the prayer he had made originally. And that's how... That's right. So,
Malaj, to refer it to the Lokayukta only.
That's correct. So, Malaj, the Lokayukta has jurisdiction. Now, once your lordships comes to the conclusion that the Lokayukta has jurisdiction, then the question is whether that jurisdiction of investigation has been exercised properly or not. There is no other question to be answered. Now, how will your lordships decide that on your own? It's just not possible. That's not the law, Malaj. And your lordships, with the greatest respect, should not even attempt to do it. Because it's in a sealed cover. Even if your lordship looks at it, even if your lordship disagrees, either the matter has to be reinvestigated, or you have to give the report to both parties and let them argue. But it can't be done suo motu by your lordships yourself. That's not permissible by law. That's the point I was making, Malaj. It's not permissible in law, Malaj. Right? So, this, Malaj, broadly are the submissions that I wish to make. Now, Malaj, one matter which is of somewhat concern to me, Malaj, because my learned friend, Mr. Maninder Singh, mentioned in his application and also argued before your lordship in his affidavit that, see, the day this was done, the chief minister withdrew consent. Remember?
No, that's
He
not-
made that submission. In
No
paragraph
submission.
5, I state that immediately after the jurisdictional court had referred the matter for investigation,
He's not made that submission at all.
On the last day,
Where?
additional
Last
affidavit,
occasion.
last occasion.
on the last day he made that submission.
It's in black and white in the affidavit.
No, maybe.
It's there,
affidavit,
it's
but
there.
he has not made his submission.
I'll read it out. I'll read it out. I'll read it out. He has said so. I state that immediately
I
after
had
the
only pointed out that. the
one
file
second,
taken away
Mr.
by
Maninder Singh, we
That's
did
all.
not interfere with your submissions.
Mr. Sibal, you should
Allow
have
us,
some patience
please.
also.
No, no,
Allow
no.
us, please. Allow me, please, to argue.
Yes,
You
yes.
should have been here. I've been called upon by the court to say something.
Sibal sir, yes.
In their application, paragraph 5, I state that immediately after the jurisdictional court had referred the matter for investigation, the respondent number 9, who is at the helm of affairs of Government of Karnataka, withdrew the consent accorded to CBI to investigate into matters in the state of Karnataka, apprehending an investigation by CBI involving himself and his family members. Mullah, in fact, what happened, the consent that was withdrawn was with respect to central government employees.
Read it from 10.
Mullah, the central government employees were allowed to be investigated by the CBI
No, that's
and
only
we
now,
withdrew that consent.
sir, that's only government. He has not present into service at all.
What is the market?
No, I heard him argue it, Mullah, last time. I was there in court.
Oh, I don't remember.
I remember, Mullah.
Sorry,
I
sorry.
remember, but
Then
anyway,
yes.
if he is not arguing it, that doesn't matter. Mullah.
He's saying he's not arguing it.
That's good. That's good enough, Mullah. I don't want anything more. I just wanted to mention I was a little pained by that, Mullah. Now, Mullah, now let's see, Mullah.
Lot of pain on the-
There's a whole history of matters
The way is also-
where Lokayukta has prosecuted, Mullah. He has prosecuted page 533, Mullah,
Of the case compilation.
of the case compilation.
Where is
Handed
this?
over by us, Mullah.
Volume 2.
Volume 2.
Just 1 second. Just give.
What's the time?
115.
We have airdrop the.
1:15.
Page?
Mullah, kindly see page 533. Look at the kind of people, para 199.
533, sir.
Yes, Mullah. Volume 2, Mullah.
That's the second.
This is Veerapur there. Where, that's ACB's case.
Please, Manoj.
Yes, yes. Yes, sir.
Your Lordship sees that, Mullah?
Yes,
Your
sir,
Lordship sees?
I'm at 533, yes.
Now, para 199, Mullah.
Yes.
Look at the people who have been investigated
And charge it.
and charge sheeted by the Lokayukta. Right up goes, just see, Mullah. And now, Mullah, it is being argued that these chief ministers should not have been investigated. They should have only been investigated by the CBI because the Lokayukta is not an independent authority.
174 also.
Then see 174 as well, Mullah. Para 174. During para 174, during the year 2011, the Lokayukta, while exercising powers under the provisions of so-and-so Act, has made the Honorable Chief Minister and the Honorable Minister who were in power at the relevant time to resign and then send them to prison by creating history in the state of Karnataka and become a model to the entire country. It is also not in dispute that at one point in time, since the son of the Lokayukta was involved in corruption charges, the Lokayukta was made to resign. And that has become possible in view of the provisions of the Act. Lokayukta Act and the PC Act. Such was the independence of the Lokayukta and its effective functioning in matters of utmost importance from the date of the inception of the Lokayukta in the year so-and-so till 2016, the date of passing the impugned executive order under 162 of the Constitution for more than 3 decades.
To create an anti-corruption bureau to investigate that which Lokayukta police would investigate.
They tried to create an anti-corruption bureau, Malats, in matters which the Lokayukta was to prosecute, and that was set aside. So, Malats, therefore, let's be clear on this thing.
No, the
Argu-
office of the ACB was abolished by a judicial